Okay, discussing how to divide the credit card debts in a Texas divorce. Remember to talk to a licensed lawyer about your individual facts, as this is intended for information purposes only and it's not legal advice. But jumping right into it, most every couple getting a divorce in Texas they're going to have some credit cards and some debts associated with those. So if you're attempting to settle out your divorce case amicably, which we always recommend, you're going to need to know what are your options. Do we have to split everything 50-50? What can we do to divide our credit card debts as a part of this divorce in a way that the judge is going to accept it at the end? And so that's what we're talking about today, how to divide the credit card debt in a Texas divorce. Basically, you're going to have three options. And the first one is going to be option one, your most common option, and that is spouse A takes all the debts in her name, spouse B takes all the debts in his name, meaning spouse A took out a credit card with Bank of America. Spouse A is going to pay that debt to Bank of America after this divorce, and spouse A is going to keep that Bank of America credit card and use it as she wishes. Okay? And looking at option two, basically this would be that spouse A, one of the spouses of the marriage, takes all of the credit card debt, whether it's in spouse A's name or in spouse B's name. So you could see that that's a broad spectrum of options, because in option two, this person is essentially taking all of the credit card debt, regardless of who took it in the marriage. And that could be decided on by the spouses for any number of reasons. Perhaps spouse A is the only person that's able to pay the credit cards off. Perhaps spouse A is at fault for the divorce taking place, and that's what spouse A and spouse B have decided is fair. Any myriad of factors could play a role in how to divide these things, because Texas courts, and probably every court in the country, likes to see settlements when it comes to divorce. A judge is not going to generally deny a division of credit card debts as long as it's just and fair for the reasons that the spouses may have. Option three is an option that essentially would wipe out the credit card debt. So the spouse A and spouse B use an asset that they have in their marital estate, such as the house or perhaps some furniture, to pay off all the debt so that there isn't any debt to assign as a part of the divorce. Okay, now if you are going to think about kind of the creative solutions to how to divide this credit card debt, you could think about it this way, okay? Say spouse A has $30,000 in credit card debt in her name. Spouse B only has $2,000, and they've been married for the last 20 years, and that is their debt picture, okay? Spouse A could be awarded something on the other side of the balance sheet, such as $28,000 in furniture or $28,000 of an account, or something that would essentially make it so that spouse A is walking away with a net value of negative $2,000, and so is spouse B. Okay, so any number of creative solutions can be had when you're trying to get a settlement for a divorce. And this particular example gives a 50-50 divide, but it doesn't have to be a 50-50 divide. What's just and right may not be an exactly equal divide. Okay, now I want to talk for a minute about the idea of using the furniture or another asset to wipe out the credit card debt as a term of the divorce, because it's important to understand this concept. There is, with every purchase that either spouse made during the marriage, there is a contract that you probably don't remember initialing or tapping the I agree button on your computer that you signed in order to have that contract. And that contract is going to be something that is very important in what will happen after this divorce is over. So imagine this scenario. Spouse A, call her Sally, has an Amazon credit card, and it has a balance of 1.5K, okay? And the spouses decide that spouse B, call him Bob, is going to pay that credit card off for Sally as a part of the terms of this divorce. So the decree, the final papers, order that Bob is going to pay the credit card in Sally's name. And after the divorce is over, Bob doesn't pay the credit card, and the credit card sits there and it incurs fees, and eventually Amazon creditors are going to go after for collections. And the important thing is here is the Amazon creditors have that contract with Sally. So while the decree orders Bob to pay the debt, Sally has the contract with Amazon. And because Sally signed that contract and Sally was the only person there, Amazon is not at all impacted by a divorce decree. Amazon is going to go to Sally to pay that debt. Now, because Sally and Bob had an agreement that Bob would pay, Sally can enforce her agreement, her contract, if it's written properly, against Bob in court, basically a breach of contract action, but an enforcement action. But nonetheless, it would have been better at the outset if Sally somehow was able to come up with a settlement where she would pay off her own credit card so that that risk exposure for her credit is not there to given to Bob after the two of them dissolve their marriage. Again, bringing you back to the furniture here, if there's some asset in the marital estate that can be sold to satisfy joint credit card debt or somebody's credit card that isn't going to be paid by them in their name alone, it may be the best way to go to reduce exposure after the divorce. Okay, so if you have joint credit cards and you can't pay them off, your decree can and should order that neither party is permitted to incur any additional indebtedness on those cards. There should be an injunction as to those credit cards. So this all comes down to decree language. Your final divorce decree has the terms of how these credit cards are going to be paid. Your final divorce decree is written by your lawyer and reflects all of the things that you and your spouse decided on, and now it's in basically a decree, an order of the court. And so your final decree of divorce needs to be specific about your credit card debts. It should list each creditor. In this example, it's Chase Bank and the redacted account number of your credit card so that there's no question that spouse A disclosed the credit card to spouse B, spouse B signed off on the fact that spouse A would be paying it, and vice versa as you go. The decree needs to specifically list each credit card, okay? Writing that spouse A is going to be responsible for her debts in her name, while spouse B is responsible for his debts in his name, that's improper decree drafting, and it won't help anybody in the future because it's basically a non-sentence. So what we're saying here is this final decree that divides your credit cards is really important. You need to look at it really carefully. Now, if it is the case that Sally is going to pay Bob's credit card or vice versa, or if there's a joint credit card, there's more questions that need to be answered in your decree to help protect you. What is the balance on the credit card? What is the monthly amount that's due? What date each month is that credit card payment due? What fund will the spouse be paying the amount from? And to where is the amount to be paid? So for instance, if there's a financial institution, have the actual address where that amount is going to be mailed and how it's going to be done. All of those details may seem ridiculous, but when they're listed in the divorce decree in a specific way, it's such that a spouse can enforce those terms into the future. The more specific, the more protection you could say is there. So in other words, how can you divide your credit cards? You can divide them any way you deem fit and best. Just understand some of those pros and cons that we talked about. And with that, we're going to sign off. Thanks for stopping by.